G'day, my name's Dave Pellowe and I'm joined again today by someone who viewers of Pellowe Talk will be familiar with, Professor Augusto Zimmermann. Augusto, thank you for joining me again.
It's a pleasure to be with you again.
Now we've been very busy for the last few days. We've been travelling around Brisbane together, you're over visiting from Perth, and we've launched the third of your books. The first one I've thoroughly enjoyed. It's the Christian Foundations of the Common Law, Volume 1, England. But you've actually done it in 3 volumes. The second one was the United States, and the third one we just launched a couple of days ago, Australia. So tell me about the Christian Foundations of the Common Law in England. England first.
Well, in England, it was, if I can be more precise, the common law didn't bring the Christian principles. It was actually a confirmation of these principles that William the Conqueror brought from France. And the whole idea of William the Conqueror was that he believed the laws in England had been corrupted and that he wanted to re-establish the Christian foundations. I'm not so sure whether this was an excuse for his invasion or not, but his whole goal and his claim was to restore the Christian foundations of the law. And that foundation comes from the Anglo-Saxon kings. It comes even during the times of the Roman occupation of England. So it's a much older tradition. Okay. And the book covers the whole thing, start even during the Roman occupation of the island.
So tell me about how the common law evolved with a Christian influence or Christian foundation in England after William the Conqueror.
Well, especially with William the Conqueror, the common law was heavily based on the idea of what we could regard, and the common law is regarded as the law of reason. The whole idea about the law being based on objective standards, based on the idea that the law is not really a product or an outcome of government. It's actually a law coming from a higher authority. So that is based on the idea of a higher law jurisprudence, whereby judges do not really create the law, but judges are more discoverers of the law.
Wow. That's a profound difference.
That's a profound difference because most judges these days, they think that they are lawmakers.
Yeah.
But this is not the rule of law.
Yep.
That's the rule of judges.
Yep.
It's a very different thing believing that we have the rule of law where even judges are under the law, and the rule of judges where judges make the law. Another thing is that our tradition doesn't say that the parliament can violate higher law. That meaning that if the law enacted by parliament violates basic rights and freedoms of the individual, it should be declared invalid in accordance with the opinions of the first common lawyers, including Sir Edward Coke. Edward Coke had something to say about parliaments trying to create laws that violate fundamental rights and freedoms. They are void.
Yep. Now, tell me about the common law the Christian foundations of the common law in the United States.
Well, the Americans in many ways are more English than the English themselves. That's an interesting thing because the American Revolution was entirely based on these principles that I have referred to you. Basically, the American founding fathers thought that the English system had been corrupted to the point that they felt they were being oppressed by the British government,
right.
In particular in the person of the king. So what they thought is that they could re-establish the rule of law in England, and that's why they declare in the very important document, the American Declaration of Independence. The American Declaration of Independence is actually very much based on English principles derived from natural law. For instance, the proclamation that we are endowed by God with inalienable rights, rights to life, rights to liberty, and right to the pursuit of happiness. That means basically that these rights are not given by the government, so the government has the obligation to be a protector and not undermining these rights.
It's a very important thing that I love about the law and I hate about politics, for the way that politics has butchered this aspect of the natural law, and that is that government's role is not to grant these rights, but to observe these rights. And they can't create rights that don't exist. They can't create rights that contravene or trespass or violate natural rights. For example, the right to kill your baby is a fraud because you're violating that living human's right to life.
Absolutely. That would, for instance, be very clear in the writings of, for instance, Samuel Rutherford, even though he was not an Englishman. But Lex Rex was understood and read by the Puritans in England. And this is an idea that if the government violates the basic rights of the individual, especially if the government decides to shed the blood of the innocent, the government probably ceases to obtain proper legitimacy. And that's because the right to life is the most important of all rights. It's impossible to be able to exercise any further right if you are killed. So the right to life is the first right to be protected. Yes. Any government who violates the right to life is in conflict with the whole idea that the government is a protector of the first and most important right of the individual, the right to remain alive. Only God can take away this life.
It's a tragedy of modern society that governments think they are a law unto themselves. That like the king, when the Magna Carta was necessary, the king thought he was the full embodiment of the law, and anything he said was the law because he was the law. And there was no other accountability that if he said it, and now parliaments believe it of themselves.
Yes.
If we legislate it, it is true.
Yes.
It is moral.
Yes, because the king believed that he was so enlightened that he could actually be the voice of the law, that he could be the personification of the law, that his opinion would constitute the law. That's not different from what the parliamentarians think these days.
No.
That's not so different from what many judges think these days. So in many ways what's happening is a sort of reenactment of the idea of enlightened despotism, that your parliamentarians think that they have the capacity to be a law unto themselves. So this is a very dangerous idea, and what Coke did, Sir Edward Coke, in his interactions with James I in the early 17th century, is to remind the government at the end of the day, because in those days the king had more power than parliament, but that can now be applied to parliament in Australia, that the parliament in Australia is under God and the law, because the parliament is derived from the law. So the power of the parliament was given ultimately by God, but by means of the Australian people.
Yes.
So it's a very important thing to bear in mind. And what Cook did was to remind this to the king, and told the king that by being under God and the law makes him king, and he has to behave under the rule of law. That's how we can have the whole idea of governments that can be accountable to the people.
It strikes me that our parliaments today are very far, the farthest possible from the humility and the service of the attitude of service that's required of lawmakers.
Yes.
They no longer feel privileged to discover or observe law, but they now feel that they create law, and that would not be a remarkable statement to them, even to perhaps most of the viewers, that legislators and judges, it's unremarkable to say they are lawmakers now, but that's actually incredibly arrogant, incredibly egotistical and humanistic, and it's what in the early 13th century led to the tyranny of a king who thought that he could do whatever he wanted, oppressing and violating the individual's natural rights. And that's what we're seeing That's what we're seeing now with crazy precedents, and we're probably still chatting about America, crazy precedents like Dred Scott.
Yeah, Dred Scott was one of the terrible precedents, and that is regarded by many as the cause of the Civil War in America, when slavery became constitutionalized via the Bill of Rights in the United States.
As if that was ever in the Constitution.
No, it's not, and
Of course not.
that's an instance of judicial activism. And in many ways, the rationale behind Dred Scott is exactly the same rationale that 100 years later legalized abortion in America.
In the Roe v. Wade
Yes,
decision.
a complete unconstitutional,
Yep.
completely unconstitutional decision.
And again, more recently, with the homosexual marriage decision.
The homosexual marriage is one of the most outrageous decisions.
Imagining, fabricating things in the Constitution which were never there and still aren't.
Yeah, it's more than that, claiming to be gods, because I'll tell you what they did. They basically claimed that they have discovered a fundamental right.
Yeah.
A fundamental right cannot be dictated by the judges. By creating this so-called fundamental right, by inventing this fundamental right, they actually deify themselves. Because a fundamental right is coming from a perspective that tells you that these rights are natural. That's the same as to say that these rights belong to you as a human being, and they are not conferred by an external authority. When the judges decided to say that the right to same-sex marriage is a fundamental right, they actually started to corrupt the idea that the fathers in America had, that these rights, which are fundamental, rights to life, liberty, and property, are not to be creations of the state, but are to be protected by the state. Another thing that you have to bear in mind with this decision is the undermining of the Constitution itself and democracy itself. Even if you believe in same-sex marriage, and people have the right to think that this somehow might be a good thing. I personally do not agree with this position.
Of course.
But I would say that democracies should be respected. And in America, we have unelected judges make such important decisions, which is undemocratic.
Right.
Another thing is that it
By a
undermines
majority of one person.
state rights, because the Constitution of the United States has reserved this area of law to the American states.
Yes.
So it's not a power that should be exercised by the federal parliament, namely the Congress in America.
So clearly they've ignored the Founding Fathers' wish for the states to be empowered and for the federal to be limited in its power. But talk about, I think it's important to talk about the exaltation of precedent above the Constitution, above the natural law, whereby very bad decisions like Dred Scott, or perhaps a better example is Roe v. Wade, are somehow enshrined as holy and unassailable.
Well, this is another very outrageous distortion of the common law tradition, because the common law tradition was based on the idea of right reason, the idea of the establishment of decisions even in accordance with objective standards, as I mentioned, based on a tradition of rights and liberties. What happened with this particular decision in America, and Roe versus Wade you refer, is that judges have created novelties and added novelties to the system.
Interesting word.
Judges have actually decided to be more faithful to acts of judicial creativity than actually to the original intent of the drafter. And by doing so, what they do is to distort even further and further the meaning of the law by evolving, not from the Constitution, even the Constitution itself, but evolving their interpretation of the law as evolving from this precedent. So the precedent becomes more important than the original document itself. And in a couple of years, let's say 20 years' time, 30, 50 years' time, everybody forgets what the Constitution actually meant. And what we have is an act of worship of precedent, where judges and their opinions are more important than the spirit and even sometimes the letter of the law.
Wow. let's move finally to volume 3, which I can't wait to get into, Australia. Tell me about the Christian foundations of Australia.
Well, Australia has a very important, amazing Christian foundation. By the way, when the English settlers occupied this land, they actually had this idea that the common law was intrinsically associated with these Christian principles of natural law, of justice, of freedom, of even the idea of natural justice has a connection with the idea that it is natural, it's not artificial, it's not created by the state. Everybody has the right to due process of law and so forth. That's coming from the Magna Carta. Magna Carta was not based on the idea that the drafter of the document was creating something that would be out of the blue, but not really created based on fundamental principles. Langton was an archbishop, and what he tried is to base this particular document on the 5 first books of the Bible. But what I have to say about this that everybody needs to bear in mind is that the common law in those days was considered to be so associated and so connected with Christianity that an attack on the common law, an attack on Christianity would amount to attack on these two, on the common law and Christianity. So if you attack Christianity, that would be considered an attack on the legal system itself.
Yep.
Because it was so intertwined, they were so interconnected that it would be impossible to disassociate one from another.
Now, I quite often have armchair experts who like to throw grenades and then run away without any real academic or intellectual defence of their assertion. But these armchair experts like to say Australia is a secular nation. You've got a chapter in the 3rd volume of your book called The Myth of Secular Neutrality. Talk to me about that.
Well, this is what I call a myth because the idea of secularism is being corrupted. Originally, the idea was that you have a separation of the institutions. Namely, you have church and you have state. The whole idea of Christianity is to avoid concentration of power, because power corrupts, and absolute power, as Lord Acton said, corrupts absolutely. So this whole idea is based on human nature. We should never ever give too much power to people, because people can't tend to be corrupted by power. So the whole idea of a secular and religious is that basically we would have a state that would be independent from the church, and you would have a church who would be independent from the state. But ultimately, both of them having different spheres of sovereignty, and they would be both accountable to basic principles derived from natural law, derived from the idea that both have to give an account to God ultimately. But what it means in terms of the practicality of things is that people who are religious are not prevented from being engaged in politics.
Right.
They are not prevented from exercising their opinions.
Yes.
It's more about protecting even these people from the abuses of governments. Because Christianity is very much based on the idea of freedom.
Yep.
It's very much based on the idea of the law of liberty.
Yep.
The God of Christianity is a God that sets you free, and
Yep.
free you should remain indeed. So this whole idea is about, let's decentralize power, let's give people
Right.
autonomy, let's give people freedom,
Yes.
and let's allow the church to be free. But the church also cannot get so connected with government to the point of ceasing to exercise its proper spiritual role.
Right. I like that word, that decentralization of power. That really makes sense. It's complementary to the model of federalism, where it's meant to be each of the states that are sovereign, not the Commonwealth.
Yes.
The Commonwealth is meant to be limited in its power, and the same, that the church is not meant to be sovereign in its power, but nor is the government. Mm-hmm. That there's meant to be this decentralization of power. It's not meant to emasculate the church beyond having a voice or an influence or or religious people from having a vote or the ability to participate in debate. A lot of these people, and forgive me if you're one of these people, but I think this is a very stupid opinion, that Christians must not bring their Christianity to a public debate or a public office, as if they're meant to take their brain out or their heart out before they go into the voting booth or they go into the parliament. But what a stupid notion.
Absolutely.
Like, what are you going to ask somebody to, oh, I promise I'm not believing in the Bible when I vote this way?
No, you can imagine if John Locke had done something like that, because he's the spiritual foundation in many ways, being a very committed Christian. He is considered to be the founder of classical liberalism. And in many ways, the American Declaration of Independence is based on Locke's ideas. But Locke was a very committed Christian. And the reason as to why we could have constitutionalism, the reason as to why we have constitutional government, as to why we have separation of powers, is because of Christians believing that the government has to give an account to a higher authority.
That's
they
right.
established a higher law jurisprudence. The whole idea of having a constitution is to make it possible to limit the power of the state and to allow people to be free.
Yes.
Because freedom is a very important principle in Christianity.
Right.
So we owe to Christianity all the blessings that we have in this country, the blessings of limited government, the blessings of individual rights and freedoms, the blessing of choices, and the blessing of living in a prosperous society as a result of a constitutional framework that make a society to work it properly, and without the chains and the boundaries caused by the oppressive governments that you find elsewhere,
Yes.
where Christianity is not being an influence.
It's a remarkably Christian virtue to have, it's a mark of the best laws in the world, are the Christian laws, because they have equality under law of all, men, women, children, every living human. We see justice has a blindfold. There's no
Yes.
discrimination or no partiality for any of her petitioners. Justice will divide and rule and weigh everything on the merits of the case, not on the merits of the person.
Exactly, and that's because, I must say, that, adding to what you are referring to, that's what Jesus said.
Exactly.
And that Jesus said that we are all equal. Paul, in one of his letters, says that everybody is to be treated equally. There is neither Jew nor Gentile, neither slave nor free. We should all be free.
Yep.
And there is also the idea there is neither male nor female.
Yes.
That is an idea of liberation. And that's why in the common law tradition we have the idea that everybody, regardless of gender, regardless even of religion, should be treated equally.
It's
before the law.
remarkable you mention Paul, because he was obviously a citizen of Rome. And Roman law is something that's offered as sometimes by cynics as a comparative to, you don't need Christianity to have good laws. But what they fail to understand is Roman law was hugely barbaric. They certainly didn't have equality of citizens. You had women and children being owned by the male heads of the households, a true patriarchy, where the husband and the father literally had the power of life and death, complete discretion over his wife and children. They were his property. It was Christianity that said, well, women also have parental rights over the children.
And that's why,
and they are not the chattels of their husbands.
and that's why in Christianity we had more women joining initially the Christian movement and then bringing their husbands along with them. Because first of all, the husbands could see the transformation in the life of their wives. And so many women even held positions of leadership in the church, because what Christianity treated women in a very different manner, even following the example of Jesus Christ. Because Jesus, the first people who saw Jesus after his resurrection were women.
Yes.
And he had that amazing encounter with the Samaritan woman. His disciples were quite shocked because they were not used to see a man, especially being a Jew, talking to a Samaritan.
Yep.
Jesus elevated the status of women, And also
That's right.
this whole idea about protecting women through no divorce rather than false divorce. What we had in the past is that divorce was forbidden so that women would not get abandoned by their husbands,
Yes.
as it happened in ancient times when a man could dispose of the women at his will. So basically what Christianity did is to elevate remarkably the status of women. And that's why in the West, women enjoy far more freedoms than in any other part of the world because of the Christian influence.
Yeah.
To be frank with you, all women should be very grateful to the blessings of living in a country that has received the influence of Christianity.
Absolutely.
Because that is from this influence that you can treat everybody, regardless of gender, equally before the law.
It's a remarkable feature of Christian Western culture that the hallmarks are liberty, equality, and natural rights. And I fear that, look, the reason this is important to remind us of, the reason you should get these 3 books by Professor Augusto Zimmermann is because we're losing this in our culture. We're losing the value and the appreciation of our Christian foundations, where we're now beholden to relativism and this positive law where if you were elected to make a law, then whatever law you make must be moral, which is a stupid proposition. But we are returning to these pre-Magna Carta days of where the rule of the king or the rule of the government is somehow absolute and not subject to natural law. Thank you for your work, Augusto.
Thank you very much. It's a great privilege to talk to you. God bless you.
Thank you. That's Professor Augusto Zimmermann, and this has been another episode of Pellowe Talk. If you get any value out of these and would like to see more of them, please consider becoming a monthly partner for as little as $5. There's a whole bunch of people doing that at the moment, and it goes a long way to keeping this work going. It's very, very important that we keep presenting these ideas which are not presented and are not debated in the mainstream media. You won't see this in the news. This is very important. If you think this is important for culture, please chip in just a little bit, or more if you can. There's also merchandise that you can get on my website. And make sure you also subscribe to the email newsletter there. That's davepellowe.com. Look, go to davepellowe.com right now and order these 3 books from Augusto Zimmermann. You'll be able to get them from the shop button in the main menu, and we'll be pleased to mail them out to you as soon as possible. And don't forget, if you're watching on YouTube, that you like the video, you subscribe to my channel, and you also click the little bell icon right there to make sure you see new videos when they get updated. And I'm also on Facebook, Twitter, Instagram, and SoundCloud. And look forward to seeing your comments beneath this video. Click on the links for more information, and we'll see you in the next episode of Pellowe Talk.